Okay, I really can't oversell this. We really have some history in the making underway in the Fulton County courthouse in Georgia, the case in which the former president, Donald Trump, is accused of RICO violations. He, and along with the 14 other co-defendants, today in court, making the argument in front of Judge Scott McAfee that the case should be dismissed because anything said was not against the law, in fact, was protected by the First Amendment. So the prosecutor, Will Wooten, has been making his counter arguments or responding to the court's questions, and that's an important point here. Judge McAfee has been great at interacting with the attorneys to ask questions when he doesn't understand. More like an appellate argument. You don't often see the judge so proactive in a case like this, but kind of high profile. So let's get back into court for more of this hearing.
They can't stipulate just for the purpose of this argument. If the fact is stipulated to, it's stipulated to in the entire matter, is our position. They'd have to stipulate that for a false statement, that the statement was false, that it was within the jurisdiction of a department or agency of state government. They knew it was false, going beyond just the allegations in the indictment, going to, things that they've indicated in their pleadings are required to for a conviction. They'd have to agree that they knew that those statements would come to the attention of a department or agency, et cetera. So I don't know that they're willing. To me, that sounds like a guilty plea.
Well, let's pause there for the purposes of an as-applied First Amendment challenge. Mr. Nolowitz, any thoughts on what facts? If we're just looking at the four corners plural of this indictment, what facts are to be stipulated to or agreed to?
I mean, I think he's right. I'm not going to stipulate the veracity of the facts for all purposes going forward. I think
that's just for the purposes of an as-applied First Amendment challenge.
As-applied First Amendment challenge.
That everything in here is alleged.
Everything in here. I mean, again, we're not stipulating to it for trial or for evidence if they are for. But if you were to look at everything in that indictment and say, just like on a civil motion to dismiss, we're going to take as true everything in there. It doesn't stand under a First Amendment.
Which is just your general demur framework, right? Mr. Sadow, is there anything you wanted to add there?
I would echo that position and have done so in my motion itself, indicating that for purposes of the First Amendment as applied challenge, it's undisputed as to the allegations and vermins in the indictment.
Okay, Mr. Wooten, back to you.
Judge Hall does not say that the defendant in that case stipulated for the purpose of an as-applied challenge. It says that they did not contest the facts, period. So our position is that you don't get to, stipulate to the facts here, but then contest them here. We do not. I heard from the other side you doing a demur, but this is not a demur. This is essentially a plea in bar based on a constitutional challenge. It's not the same thing. And to be clear, in a demur, the other side's not stipulating that the facts are true. The court is taking them as true and making its determination as to whether or not the indictment is sufficiently pled. So our position is that there's no such thing as stipulate for the purpose of just this. That doesn't do it. That they would have to stipulate, again, not just to what's alleged in the indictment, but the proof that would be shown at trial, because an as-applied challenge looks at more than just the indictment. It looks, that's what Your Honor exactly pointed out in your initial order on this, is that you can't go just by the indictment. And in Hall, they don't go just by the indictment. There are some additional facts that are stipulated to. And so I don't think that works. The state's position is that approach does not work, that the court still is not able to make a determination, even if they stipulate for the purposes of that motion that these things are true. We don't think I don't think that's the thing you can do. I don't think you can say, we're going to halfway stipulate. Either you do or you don't. Either the fact is stipulated, it is a fact established in the record as true by stipulation, or it's not. It's not a thought exercise. And in Hall, they agree that the facts are true, unequivocally. That's it. And so the state's position is Hall does not apply here because that is not what's happened here. I'm going to move to the other case cited by Mr. Sadow. That's State v. Davis. He cites that as precedent. That's a facial attack. And as the court well knows, a facial attack is presumptively ripe. The argument in a facial attack is that it could never be applied constitutionally, so there's no need for a development of a factual record. So we agree with the court in its first order on this issue, that these issues are just not right. There is not a fact. There's no facts in the record.
So prosecution gets a chance to make its case, to keep its case alive, whether you call it a demur or a motion to dismiss. It's an attack on the paperwork, on the pleadings. Hey, this is a crappy pleading. It doesn't tell the court and ultimately a jury that there's anything to be acted upon here. Katherine Lizardo here and Judge Fanon Rucker. Katherine, let's talk about one of the arguments made by counsel early on, and that was that this is not new. You know, look, we have Stacey Abrams. She continues to say she's the governor of Georgia. I think it was in 2018 when she did not win that election, according to people counting the ballots. They mentioned 2000 with Gore and the presidential campaign that took place in Florida. This is not new. People have constantly disputed the results of an election. What do you think? What do you think about that?
Well, I have a different perspective with that argument. He's saying it's not new, but for this particular proceeding of the demur, what's new is that this is the first impression of law in Georgia using the RICO case in the indictment. That's what's new here, and that's what the judge is trying to tell them, that you have to let me understand why this RICO case, as applied to the indictment, the four corners of the pleading, is unconstitutional. But I haven't heard anything that would support that, because here the prosecution is what they're doing is saying the law that they said support their argument is really not supporting their argument. That's one way that practicing lawyers argue why a case that seems to be supportive is not really supportive. And they're saying they're distinguishing that law, which is the Hall law, from their own case.
So, Judge, we won't have any hanging chads here to deal with like we did back in 2000 in Florida in the Bush-Gore dispute. But every time an attorney makes these back and forth arguments, it starts to, you tell me from the bench, your perspective, make you think, well, there must be some triable issues of material fact here because something's missing. Whether I give the prosecution leave to amend and put in some of these things that maybe they left out, or I think it's sufficient the way it is, on its face, I can't get rid of this case.
Well, you bring up a point about what is agreed to and what the parties stipulate, and whether or not that presents a judiciable or a cognizant difference of opinion that justifies a trier of fact ultimately making the decision and it not being thrown out. The second issue is, in all courts across the country, judges are instructed generally to allow parties their day in court. If the law and the facts can be read in a way to justify a complaint, to justify in a criminal case a complaint or in a civil case complaint, then the ultimate objective is for the matter to be played out in court so that all parties have the opportunity to present their sides. And so that weighs heavily on the ultimate decision about whether or not it should be thrown out on a technicality or whether or not there is sufficient information presented to justify it actually going to trial. And I think here, going back and forth, you got to let the court decide.
Yeah, and I think
meaning at trial. Of
course, and the court's default is, in the absence of something pretty darn strong, I got to deny this. We got to let this play out as it should. And it's important for you to mention there, as you mentioned, Judge, that these types of motions are so rarely granted. When they are, and if they're taken up on a writ, they'll come back because of that same theory that these cases need to play out. I'm not going to make a decision to end a case based on what somebody pled, maybe poorly. Let's take a break. We'll come back again. Fulton County, Georgia is the scene. Former President Donald Trump trying to get the case against him tossed. We'll be right back.